Patience as I had to practice a little law. Hopefully that won't be a recurring problem here, at least on Thursdays. I want to do it all the rest of the time, though. All right, I call to order the Senate Standing Committee on Judiciary for our first meeting. We've got one bill on the agenda, and as President Stivers makes his way up, I'm going to go ahead and have the Secretary please call the roll.
Senator Berg, Senator Kerr, Senator Neal, Senator Schickel, Senator Schroeder, President Stivers, Senator Turner, Senator West, Senator Wheeler, Senator Curl,
Present.
and Chairman Westerfield.
Here. Seeing that we have a quorum and we are authorized to do business, President Stivers is here on Senate Bill 20. I give you the floor, sir.
Thank you, Mr. Chairman and members of the committee. I want to give a little bit of history. Having gone through redistricting and actually being a product of a 1994 case that redistricted in 1995 that put me in Moorhead, Kentucky, in Rowan County. I've been very familiar with the process for years. In 2014, I think I was named in my official capacity in federal litigation over a redistricting suit because we did not redistrict in the 2014 session. Then Governor Steve Beshear called us back in because the federal court stayed the proceedings to allow us the opportunity to draft districts based on the 2010 census because we had drawn them and then they were thrown out, and based on what the House under then Speaker Stumbo and crew had done. So we had to go back. We did not draw them, thinking that the cycle was near, but the federal court stayed everything. We came back in, and in a week we passed maps. The federal courts looked at them and then dismissed the action because they felt they met all constitutional parameters, at least of those that were brought in federal court. What I saw at that time was what the federal courts did. They do not allow, or their rules do not allow, a one-judge panel. The chief judge of the Sixth Circuit, which sits in Cincinnati, appoints a three-judge panel to review any election contest that's filed under federal law. If there is a need for, if it is a joint case, and I can get into the details, if there's a joint case of where there are state and federal issues, there may be the need for a certification of an issue to the state Supreme Court, but in this case there was not. It was all federal issue. So the three-judge panel was appointed by the chief judge of the Sixth Circuit Court of Appeals, but they were trial court judges. And so there had always been the issue of fairness. Where do you have this? And you have multiple jurisdictions. And I think I heard Representative Jason Nemus talk about Fisher 1, Fisher 2, Fisher 3, Fisher 4, Jensen 1. These were filed all over the Commonwealth, primarily in the southern part of the state and the northern part of the state, that we should set up a process to where the issues are consolidated. And so we tried to mirror the federal system, a three-judge panel appointed by the chief judge, trial court judges, the chief judge of the Supreme Court, which is the Supreme Court Justice Minton at this time, to hear any election contests. Well, we've gone for several years without redistricting, and it became among some scholars and jurists, what does this do, and does it in any way conflict with Section 110B of the Kentucky Constitution. I don't think it does, but there are others who do think it does conflict with that. So out of abundance precaution, I don't want, me personally, and I don't think this institution wants the issue to be, is the process constitutional before you ever get to the substantive issue of constitutionality. So what this bill does is repeal that statute that sets up a 3-judge panel to hear an election contest and allow for consolidation. And so this is basically a strike-through bill, a repealer, and puts it back to where it has been for years. It is where the plaintiff resides and files the suit. So more than likely, if some people want to litigate, and I can't speak for the House map because I really haven't looked at it, but I think ours that we have proposed meets all the constitutional parameters because those have been our guiding principles. And I believe the federal map for the congressional delegation meets all federal requirements, but you can't stop somebody from litigating. But so there is certainty, and that we don't get into litigation over the process, and that if there is litigation, it can get to the substantive legal issue. I have proposed Senate Bill 20 because we need to get the issues resolved on redistricting so everyone can have an appropriately represented voice based on the legal parameters of our Kentucky Constitution and federal Constitution.
Is there a motion on the bill? A motion from Senator Wheeler and a second from Senator West. Mr. President, any other remarks you'd like to make?
No, I mean, this is what it is. We need this. We need this issue of our respective districts in the House and Senate and in Congress resolved as soon as possible. Had hoped that we could have done this in a special session earlier, but we haven't.
That makes two of us.
And so now I think this is the most certain way to get it to the quickest resolution if there is litigation filed, Mr. Chair.
Very good. Members, any questions? Senator West.
Just for clarification, I think I know the answer to this, but I'm assuming that any action would follow the normal path. So if they file it in circuit and the losing party wants to appeal, it goes Court of Appeals, Supreme Court. It would follow the same general path.
Yes, as you are well aware, and I think virtually the majority of this committee being practicing lawyers, it's going to be where the plaintiff files, and that's where their residence generally is. And, you know, some people have always thought that if they didn't get the right redistricting, they might run down to the Franklin Circuit Court because they got an advantage in the filing here. Then others would think that you might get an advantage by filing it in the Laurel Circuit Court. I was trying to remove any concept of advantage by having this done by a 3-judge panel. But when you look at 110, and I understand the argument, don't necessarily agree with the argument, it's just this is too big and too prominent of an issue at this late of date to have muddy up the water over process versus substantive issue.
And as a follow-up, so in your previous examples, so if you have multiple actions across the state, the Court of Appeals or the Supreme Court can join a group of cases or actions together to expedite.
I would hope that would be done. I don't know
but
if
they have the opportunity to do that.
I don't know if joinder, depending on the pleadings and how parties deal with it, that was the purpose of doing it this way, so all issues could be done in one action under a 3-judge panel.
Thank you.
Seeing no other questions, we got a motion and a second on the bill. Mr. Secretary, please call the roll.
Senator Berg. Senator Carroll.
Aye.
Senator Kerr. Senator Neal. Senator Schickel.
Aye.
Senator Schroeder.
Mr. Chair, explain my vote. I vote aye. And President Stivers, I'm like you. I appreciate how it had been done, and I understand the rationale for why it had been done. It seemed like a pretty good process. And I'm also of the same mind. I understand the argument, don't necessarily agree with it, but if you think this is the best course of action, I'm an aye. Thanks.
President Stivers,
Aye.
Senator Turner, Senator West,
Aye.
Senator Wheeler,
Aye.
and Chairman Westerfield.
I vote aye. Bill passes with favorable expression on a 7, I believe. Senator Schickel, were you an aye vote? Were you an aye vote, or did you? Okay. So 8? 8-0. Been asked to announce these for those watching via the web so they can know what the count is. So there it is. With nothing further come before the committee, I'll entertain a motion to adjourn. So moved. Thank you. We are adjourned. Let's